many individuals who get involved in auto accidents want to obtain settlement loans. Furthermore, they wonder if their claims are there any value. Many individuals involved in auto accidents sustain injuries that result in neck pain. The question is, what is the cause of that pain? Unfortunately, many individuals who are involved in auto accidents conclude that merely because another vehicle struck them that the other driver will be found liable for injuries sustained. However, this is often not the case. Even in those cases in which a driver's vehicle was struck from the rear pose some challenges when it comes time to make any determination as to where liability should be correctly assigned. In today's litigious society, many insurance carriers often allege that the rear-end collision occurred as a result of what is referred to as jackrabbit starts/stops. In such instances, the vehicle struck from the rear lunges forward and comes to an abrupt halt, creating a situation in which a collision is essentially unavoidable for the driver and vehicle approaching from the rear. Naturally, such instances may constitute fraud. Certainly, one is not going to obtain settlement loans in cases involving fraudulent claims. That is, of course, if the fraud is discovered in a timely manner. Individuals contemplating such claims should be aware of the fact that they stand to incur criminal penalties and fines, with the potential of actually going to prison. Now, back to the intent of this particular article. If you are involved in an auto collision and sustain injuries to the neck, it will be very important for you to determine both the cause and extent of injuries sustained. Fortunately, in many instances, no substantial injury is sustained. However, in some instances individuals sustain life-threatening disabilities as a result of these auto accidents. Sadly, many individuals actually lose their lives as a result of such auto collisions. Oftentimes providers and their patients find themselves in a catch-22. The insurance carrier will allege that the claimant could not have sustained a substantial neck injury if neither an MRI nor CT scan was obtained. However, if such imaging is obtained, the insurance carrier will allege that such imaging was totally unnecessary. Furthermore, if substantial findings are noted, the insurance carrier will allege that those findings were pre-existing. Hence, the need for competent legal counsel to help you as you navigate your way through these waters of litigation. First and foremost, if you sustain injuries to your neck as a result of an auto collision, I would encourage you to seek medical attention as quickly as possible. The longer the delay between the date on which the auto collision occurs and the date on which you seek medical attention, the more forcefully the insurance carrier will allege that no actual injuries were sustained. Not to mention the fact that the longer the delay, the greater the likelihood of a protracted course of recovery. Additionally, some life-threatening conditions may be identified that would have been missed without the assistance of a qualified healthcare provider's assessment. The insurance carrier's argument will be that if serious injuries were sustained, these individuals would have gone to a medical provider much more quickly. Furthermore, insurance carriers will often allege that individuals who seek medical attention after a protracted period of time following an auto collision do so as a result of an attorney directing them to do so merely for financial gain. In addition to seeking competent legal counsel, something which is absolutely essential for those wishing to obtain settlement loans, it will be very important for them to find healthcare providers who are knowledgeable in the assessment of injuries arising from auto collisions. Unfortunately, general practitioners are customarily not the most helpful in assessing such injuries. As I stated in previous articles, family physicians are much less likely to document the fact that you've actually sustained injuries as a result of an auto collision. Why? This is due to the fact that most insurance policies specifically exclude injuries sustained as a result of an auto collision. Therefore, the general practitioner, in an effort to obtain reimbursement from your insurance carrier, will fail to mention the fact that you presented following an auto collision. Such omissions make it very easy for the insurance carrier, once the insurance carrier obtains the medical records, to present a very persuasive argument before the jury that you went to a medical provider following the auto collision and the physician made absolutely no mention of the fact that you sustained injuries as a result of that auto collision. In fact, there's absolutely no mention of the auto collision whatsoever. The foregoing is not intended to cast aspersions upon family physicians. It is true that most family physicians are honest individuals who deal with a great deal of integrity on a day-to-day basis. However, having reviewed thousands of cases over the years, from essentially all over the United States, such omissions are so patent as to make this assertion undeniable from my perspective. Yes, those individuals who seek to obtain settlement loans following auto collisions due to the fact that they sustained injuries that resulted in neck pain were encouraged to seek competent legal counsel and competent medical attention as quickly as possible.